Started recording. Uh, Gary will let us know when we're live.
No, Amanda will, I hope.
Oh, there you go.
Absolutely. We're not live on Facebook yet, but folks are starting to join the webinar. It looks like there isn't a waiting room, though I turned it on, so I'm not sure. But so folks are joining, but I think you're on schedule to get started at 6 o'clock. Let me know when you're ready, and I can start going live on Facebook.
Jody, do you want to introduce, and then I will do
Okay.
3 and 4. And
Okay.
you
Can you hear me?
Yeah, do you want to introduce the topic, and then you can introduce yourself, and then I'll introduce myself, and then we'll go to slide 2.
Yes.
Cool.
Gary or
Yeah,
Brian, who's showing? Can somebody refresh the presentation? Because I just added a link for the article that I was referencing.
that would be Amanda.
Oh, Amanda, could you refresh your browser to get the
And I
updated
think you might
version
have
of?
to drop the link into the chat for everyone so people can actually get to it. I don't know if they can get to it from
Well, everyone should
this,
already have the presentation, right? So it's just refreshing
not
it.
not the folk, only the participants have the presentation. Only the
Oh, you're
panelists.
saying for
For the folks who
people who are
are, yeah.
participating? Okay. We're giving them the copy of the presentation? Every,
And if you guys want to,
yeah. Have we
I can
given?
I'll put it in the chat towards the end. Or do you want me to put it
Okay.
in the chat right at the beginning?
I think towards the end is good, and that way they can get on the link and they can use the templates we've created if they need to for their own schools.
Yeah, the end is better that way. They'll go without flow versus getting ahead of us.
Okay.
Read.
Hey Jody, you start tell us when you're ready.
Oh, I'm ready.
Amanda, you can
Are we,
start the Facebook.
All right, y'all are live on Facebook.
good evening, everyone. Thank you very much for joining our presentation tonight for the contract committee with Know Your Rights or Know Your Contract, Article 15, Classroom Management and Discipline. Again, we thank you, everyone, for joining us tonight. Part of this presentation has to do with this article that we'll also put in the link from Education Week. Is student behavior getting any better? What a new survey says. So we want to focus on classroom management and discipline and what our negotiated agreement says that we are responsible for and what administrators are responsible for and how we work together to address student management and discipline.
Good evening. My name is Lynn Romanek, and I'm the co-chair for the Contract Enforcement Committee, and we welcome all of you. We hope that we can help you think about managing your classroom and giving you some tools to use for yourself to get a great classroom management routine in place.
And I'm Jody Johnson, the other co-chair. We can go
So,
to the next slide.
yes. So slide number 2, you'll see we have a lot of people on our committee, which is wonderful. We're not going to read everyone's names. We're going to leave this and attach it at the end so you can see the entire presentation and use it at your leisure. All right, Article 15A, the principal responsibility. The principal is charged with the responsibility for the total conduct in the total educational program to which assigned. And we have also attached the negotiated agreement here for you to use as well. Article 15B are shared responsibility between the principal and Unit 1 members. Unit 1 members and principals shall have the authority granted by law and shall exercise responsibility for the control of pupils within their classes and the educational program. Towards that end, our next slide is going to delve into giving some information regarding the classroom, the teacher's responsibility in the classroom.
Thank you, Lynn. This is Wilbur Brinson, team member of the contract enforcement. Article 15C, educators' responsibility. Classroom management is the responsibility of the Unit 1 member. Procedures for handling disruptive students both within and without the classroom will be developed in accordance with Prince George's County Public Schools policies and procedures, in which each school by the principal or duly appointed designee and the faculty, including input by the faculty advisory council. What's your management plan? Well, according to our responsibilities, tier 1 is preventive. We want to always know what our first steps are relative to our responsibility as educators and how we identify the next steps to take. Tier 1 speaks to, has behavior. You have a behavioral concern. You have academic concerns. You have attendance concerns, or you have a social emotional concern. Those are the areas that we should be, as classroom educators, be prepared to address anytime we're dealing with students, especially when it becomes preventive. Also, relative to classroom management is very important. Classroom management not only deals with our relationships with the students, but it's about motivation as well as discipline. The Safe and Civil Schools series is a collection of practical materials designed to help create productive, safe, and respectful learning environments. The overall goal of the series is to empower school personnel with techniques to help all students behave responsibly and respectfully. Along with this process, there's several ways that we can establish classroom management and engagement with our students. What I would recommend on tonight, for the sake of time, and of course, there's more in the PowerPoint with the links. There's a program called CHAMPS, which is a proactive approach to classroom management. It is a systematic guide for teachers on how to design a classroom management plan that will help them to overtly teach students how to behave responsibly. Classroom teachers will also develop methods for clearly communicating and teaching students to meet their expectation, maximizing student on-task behavior.
All right, on the next slide, we've given you some forms to assist you in tracking. One is your teacher intervention log, which is very important. Before writing any kind of recommendation for administrative intervention as a PS 74, your administrator is going to want to know what you have done in the classroom to manage the behavior of the students. In my school, Samuel Ogle Middle School, we share this with our Foursquare. We share it with other teachers, creative arts teachers that see students. So we have a continuous running record of what's being done. If our interventions have been successful, if they have not been successful, and that way you have that 4-year record, then you can move on to the next level, which is a PS 74. This is an online form. And
one second, Lynn.
sure.
Amanda, could you click the hyperlinks to show the example of that Foursquare and then the other links so that our participants will see what we're referring to, please?
Yeah, the teacher intervention log. So this is an example of what you would put in. So you have an example there for yourself to use. And then this is the interactive PS74, which is editable. You will have the link at the end of the presentation, and you can put this in the information you need. Please remember, when you write a PS74, the administration has a specific amount of time to respond. However, always make copies. For example, we make 3 copies because our administrators need 2 copies. We keep 1 for ourselves. When you put it in the box, in the administrator's mailbox, for example, if you write it at 10 a.m., but you don't get it into their mailbox until 2 p.m., that's when your expectation of time frame should start at 2 p.m. because they have a lot of things they're doing. So this way you can, understand why they might not react to the PS74 as quickly as you would like. And then this is a PS74 tracking form. Again, similar to the classroom intervention log, we share it with our Foursquare, we share it with our creative arts teachers. So if a student's being written up on a PS74, the entire team knows about it, and then they're all aware of what's going on with the student. So, would you like me to read this one?
Mhm.
Okay, behavioral expectations. PGCPS is committed to providing a safe and orderly learning environment conducive to rigorous instruction. All students must maintain appropriate behaviors at all times, whether face-to-face or in an approved online instruction. Setting clear behavior expectations for all students is essential for creating a positive and effective learning environment. Outlined in the forthcoming slides are the key expectations inclusive of all students pre-K to 12th grade.
And what we mean by that is this is aligned with, this is Dr. Melvina Barton. This is aligned with the expectations so that you understand clearly what is expected of us, not only from the union, but what the school system actually has a level of expectation for us as far as we do our jobs. The next slide talks about the teacher staff, remember responsibilities, and this is just a short version of what is going on. The respect, not only the respect from students to students, but we also have to show a certain respect, we have to show a level of respect to our students. Mm-hmm. And then it goes on with the policies and procedures, classroom environment, absenteeism, relationships, report issues, policies and expectations, and investigations. And demonstration. These are just bullet points that we are responsible for as far as maintaining the discipline in our classrooms, as well as the discipline in the hallways throughout the school community.
I'm going to refer again to the PS74 that we saw a couple slides ago, and there are different versions of it. You and your FAC should determine, along with administration, should be determining which specifically form that you use. Now, a reminder that this becomes part of the student's permanent record. And I have heard teachers say this year, oh, but I don't want it to become part of their permanent record. People will think badly of this student, but it's super important. We're not doing it to get people in trouble. We're doing the PS74 so that people can be aware what were the issues that this student has. What might some special ed interventions be implemented for this child? So it's really important that we are making sure that these issues get reported. So membership and staff responsibilities, they're labeled there. I'm not going to read them for us, but they are really very practical things that we would think that we wouldn't need to say, but our contract definitely does say them, our negotiated agreements. What are we supposed to report? Bullying, harassment, violence, intimidation, and other things along the same lines. Making sure that we communicate in a timely manner with administration. Like Lynn said a couple of minutes ago, if the event happened at 8 a.m., but we don't get to it till 2 p.m., we cannot expect as timely of a response because we're busy, so it takes us a while to get these things done. But, there might be an emergency situation where we need to make sure that administration is privy to what's going on quickly. In those cases, we need to make sure, even if we have not filled out the PS 74, that we can connect with administration so they can come and help intervene so we can go on with our duties for the day and teaching our kids.
I'm Katie Gorman, and I teach at an elementary school. And I have heard various statements by teachers at my school and in other schools about, well, we're not allowed to use a PS 74 with the pre-K to grade 2 students, or we're getting grief from some of our special ed teachers because some of the students have disabilities. And I looked in the administrative procedures, and there are none of the 10,000s that speak to using or not using. So there's not a positive or a negative into using a PS 74 or not using it with pre-K students through grade 2. In the Student Rights and Responsibility Handbook, page 27, it does say, of course, that there are stipulations for suspensions for the younger students. In those stipulations, it talks about making sure that you fill out the Google form, but it doesn't say what the Google form is. It doesn't specify it at all. Also in our contract says nothing about a Google form. It refers to the PS 74. So I would recommend you not be swayed by an admin who might say, well, fill out this Google form. Feel free to fill out any Google form you want, but if it's not a PS 74, they don't have to respond to it in the same way. In addition, the timelines for their response and any appeal that you may have available to you by using the PS 74 is likely not available to you if you fill out an in-house Google form. As to students with disabilities, there are no regulations that prevent using the PS 74 for students with disabilities. There is the parental rights, the Maryland Procedural Safeguards Notice. I scoured that, and there are regulations that pertain to removal of a student for suspension, but that doesn't come under us. That comes under the authority of the school personnel. However, students with disabilities may be removed from an educational placement. Now, they can't just be put anywhere. They do have to be placed in an appropriate interim alternative educational
I have to go to Dr. Wang in the morning.
And it is important to remember that that is something that will happen with, of course, the principal's decision. And if they put them back in your class and nothing happens, again, later you'll find out you do have an appeal process to you. But again, the students with disabilities can, in fact, be removed from your class. There is one little caveat, though. It is important to know whether the behavior that violated the student code of conduct was or was not a manifestation of the child's disability. And as they said before, you will get a copy of this slide. There is a link at the bottom of this slide that talks about the determination of manifestation. And that really is important to understand that. There are some students, as you know, their manifestation of their disability is going to really present some challenges. But if it's not a manifestation of their disability, then they are absolutely to be held to the same disciplinary procedures that it would apply to a child without the disabilities. And that is the wording in the bottom right box from the Maryland Procedural Safeguards Notice.
Amanda, could we see that manifestation?
It's on page 27 of the link. Gotta find mine. Sorry, I'm getting mine. I can't possibly read Amanda's small one, even with my reading glasses.
She zoomed in for you.
Okay, so it does say,
Thank you.
let's see. So if within 10 days of any decision to change the placement because of a violation of the code of conduct, the parent and the child's team must review all relevant information in the child's file and to determine if the conduct in question was caused by or had a direct and substantial relationship to the child's disability or as a direct result of the public agency, our failure to implement the child's IEP. So again, I'm sure, and hopefully, we've all been documenting all the way along and making sure that we are using the accommodations that are set forth and applying a classroom management plan that also includes opportunities for the child with disabilities to succeed. And if in fact it was a manifestation, they're going to conduct a behavioral assessment and implement a behavior intervention plan. They're going to review the child's behavior intervention plan if they already have one and modify it as necessary to address the behavior. And then because the student should have been out of the classroom at this point, they would return the child to the placement from which he or she was removed, unless everyone agrees that a different placement would be beneficial to the child. So I just wanted to give you some information so that if someone says to you, you are not permitted to do a PS 74 with the pre-K through grade 2 or student with disabilities, you have some information to back up your choice.
All right, now we're going to go into Article 15D, which is the protocol that should be followed. And to note, this is when the student's behavior makes the operation of your classroom impossible. So the first step is the teacher completes the discipline referral form, which is the PS 74, as we've been talking about. The second step, the student may be excluded from the class until the teacher and the principal or the principal's designee have held a conference. The conference should be held on or before the next school day. The Unit 1 member and the principal or principal's designee may use an exchange of emails in lieu of that conference. Thirdly, the principal designates an appropriate area where the student can be sent. And in this case, the FAC can advise in those arrangements. In the fourth step, the principal will decide if and when the student is to be returned to class.
Hi, I'm Delisa Robinson, and I'm going to continue with that the process once you have completed a PS 74. So the principal has to make a decision within 4 days, within 4 working days. And I think some of the presenters have already talked about how the timing is important. So once you submit the PS 74, those 4 days start at that point, So if the principal doesn't make a decision within 4 days, then the Unit 1 member, the teacher, can go ahead and make an appeal or send it to the instructional director. Also, that stands for if you don't agree with whatever decision was made. So you can make an appeal and send it to the instructional director as well. The principal then, if you do send it to the instructional director, then whatever the principal decided, that's going to happen until the instructional director does a review and then makes a decision or makes a final decision. Now, if the instructional director does not respond within 7 days, then you can take it further and go up to the associate superintendent. And if the instructional director does not give a decision, then the student is excluded from class until the matter is reviewed by the associate superintendent. So it's really important that you document, that you have all your ducks in a row, that you keep up with the timetable so that you can make sure that we're getting the best decision for all that are involved, the student, the other students in the class, and the teacher, to make sure that the learning environment is safe and secure.
Article 15E, access to all notices. This is following up after you've done the steps as discussed by Delisa and, oh my gosh, I'm sorry, and Alicia. Now the principal is responsible, or whomever handled the discipline is responsible for that communication. The Unit 1 member is immediately involved in the education of a student and is assured that they shall. And notice even back in when you get a copy of the presentation, we have words like shall, may, can. Shall means when you look at the language that it must happen. So they shall have access to all notices of student suspension or other disciplinary data as contained in individual pupil school-based records. So that's the part where the administrators are collaborating with you, because we're all professionals, to discuss how things were handled, and you should be able to have access to those reports or notices for the student. It helps you to organize, it helps you to know what you have to do to prepare for the child that might be out, and that it was actually filed and contained.
The Board of Education shall cooperate with the prosecution to the fullest extent of the law of any individual who physically or verbally abuses, intimidates, or interferes with, interferes with a Unit 1's member performing his or her duties. This is regarding to threats. We have to take threats very serious, especially when it's coming from our scholars. A legal threat is a statement or an action that expresses an intent to cause harm or damage to a person or their property. It doesn't have to just be you, it could be your property. Threats can be verbal or written and can be made in person, through the mail, or online. A threat can be an expression of an intent to hurt you bodily, physically, or confinement. A threat can be an expression of intent to accuse you of something or cause criminal charges to come against you. A threat can be an expression of intent to expose a secret or publicize false information about you. A threat can be an expression of intent to withhold testimony or information. A threat can be an expression of intent to take wrongful action as an official, which could also come from an administrator or a student. We had a situation, and what we have to understand is that if you are threatened in any way, you, according to something that I'm aware of right now, do not have to write a PS-74. You can go straight to the police station if you feel that you have been threatened. The threat is a statement, and it's how they're going to carry that action out towards you. You can go to the police station first, file your police report, and they'll follow with the school. One of the other things that I learned through a recent incident is that when you file that report, you don't file a stay. You file a restraining order. A stay will mean that you can't be in their space, from what I understand, but a restraining order is where they can no longer come in your space, and that student will have to be relocated to another location. And of course, that's something that legal will have to confirm. So we must take all threats serious. However, if you have been threatened, you have the right to go directly to the police station and file your report. We have to take all threats serious.
So everyone, this is the conclusion of our presentation. We're going to share the presentation with you. On the very first slide, there's an article that was also posted in Education Week entitled, "Is Student Behavior Getting Any Better? What a New Survey Says," for your review as well. But please take this time now to put your questions inside of the Q&A so that we can address them.
And Jody, I just put a link to the presentation in the chat. So if anyone wants to have access to the links that were shared or the information, you can just go to that. You can get a copy of the presentation at the link.
Well, when I'm looking at here with the chat, it only looks like that we are able to access the chat.
I put it to everybody.
Okay, so maybe you have access to
Yeah,
everybody.
you can either link it to everybody or just the panelists.
Can I address, I see a question that was in the chat where someone asked, who is the instructional director? The instructional director is the person that your principal reports to. So each instructional director has several schools, so you'll have to look at your hierarchy to see who your instructional director is.
And Delisa, a good cheat for that is if you go to the employee directory, if you just put in your principal's name, their supervisor will be in that information, which will include their email address. And if they have an office number available, it'll include that as well. If you don't know who your instructional director is.
Okay, so we have a question. Is there any change regarding classroom management being proposed as part of contract negotiations?
I can answer that, although we're not done with all our proposals on that. Yes, we're discussing changes to this article to include some language about what are the rights and what should teachers do in cases where students are chronically misbehaving, but not to the point that they need to be removed from the classroom. So it's kind of like there's sort of a gap in the language, and it says, here's what you do if a student is making it impossible to teach. But there are other cases where students just keep doing the same, more low-level things over and over, and teachers need some support there as well.
And then Gary or Brian, the next question is PS 74 responses. Our admin shares a spreadsheet, not returning the actual documents submitted. Is this allowable?
It's allowable, but if you want a copy of the actual form with it filled in, then you should contact your administrator and ask for it.
That's that part where they are responsible for sharing their steps. That's in
on the form
15F, excuse me. That's in 15E. Are the different PS 74s based on school level? Why are there different forms? Well, I can take that one. There's only one PS 74. Only one. Some schools have created in-house disciplinary forms, but they are not PS 74s. Brian, Gary, any other? Is that right?
Correct.
So the two links that are shared in this presentation that you can edit is the same PS74. There's one PS74 form. So even if your school might have created something in-house for disciplinary, as we've said, if the rubber hits the road, you have to do the PS74 so you are covered.
And I would advise to everyone, when you're writing your PS 74s, if you have like an app on your phone called, I have this app called TurboScan. One of the teachers told me about it. So when you use TurboScan, you can take a picture of the document and it will capture the image, and then you can email it. That way you keep a record of what you have sent. I work in a portable, so it's difficult for me to go into the building, make a copy, and so I use my TurboScan app to record the PS74s that I'm sending, and I email it directly from that app to the administrator.
Jody, one of my teachers just texted me. She wants to know, is there a difference between the students' rights and responsibilities and code of conduct? Because in the student rights and responsibilities, it alludes to the student code of conduct, and each school divisionally, elementary, middle, and high school, seem to have a different interpretation of it. They're meshing it, especially at the elementary level, they're meshing it all as one.
Brian and Gary?
I'm sorry, could you say that again?
This is Melvina. A teacher just
Hi,
texted me. A teacher just texted me. She said, quote, because we had a meeting today, the student rights and responsibilities and the student code of conduct. They are meshing it at the elementary level to be as one. However, when you look in the students' rights and responsibilities, it alludes to the student code of conduct as being a separate entity to which Mr. House has signed.
Yeah, I don't know that's new information to me. I don't have a clear answer. I know Brian knows anything about that, but I know that there have been updates to the rights and responsibilities handbook this year, and I think those are supposed to be primary, but I could be wrong. I'm not sure.
And the reason she's asking it, Gary, is because when she went to write APS 74, that's the direction she's told. But in the rights and responsibilities, it doesn't give like the different tiers based on the consequences of the actions. That's in the student code of conduct. So that's where she's trying to get clarity, because she's told to use this when writing a PS 74.
Well, I know that within the student handbook itself, you have section, let's see here, section 7 through 11 contain the student code of conduct within the handbook. Section 2 is rights and responsibilities. So all of those are contained within the student handbook, both the code of conduct in section 7 and 11 and the rights and responsibilities in section 2.
Okay, the next question. What if you write a PS 74 and no response is given from the principal?
That harkens back to in Article 15, Section D. So the principal has 4 days from when you notify them to get back to do something or to get back to you. And if they don't remember from the time you email them or you let them know, that's when the 4 days clock starts. Then you have the ability to appeal to the instructional director. You don't have to wait for them forever. And if they don't respond to you, you know that you have a copy of the email that you sent, then that counts as the clock starting.
And I would, just for the sake of peace, prior to reaching out to the instructional director, I would just send a reminder to the principal and say, hey, 4 days have expired. Will you be sending a response? And then if you don't hear anything from there, I would go to the next step, but, probably give a courtesy to the principal again. The next question, in regard to student returning to class, that's what this is about. Can you repeat the info? Is a meeting with teacher and admin before student returns to class required? I've never had one.
I haven't ever had one either, but according to our contract, that is one of the steps that is supposed to happen. Because you guys have the principal is supposed to let you know what the decision was, like what they decided to do before that child comes back into your classroom. So it is a step, although I know with experience that is not always followed. It is one of the steps that they are supposed to take before that child is admitted back into your classroom.
It does
And-
also
and that-
say that it can be an email.
Yes, it can happen by email, but some
But
kind
the
of
one crucial part of that is you're writing the PS 74 when you have the students. Sometimes people will just put a student out and they don't follow through with the PS 74. And so they just put the kid right back in the classroom. So make sure anytime you have a student leave your classroom because of misbehavior, that needs to include a PS 74 to administration.
And everyone, that's on step number 5, and the terminology there, the language is shall be. So that means they must give you some kind of communication back.
Jody, we have someone who can't put anything in the Q&A, but this is what they ask. Will the procedures or can the procedures cover being verbally assaulted by parents, or is there currently something being done about this on a negotiation level?
The language in Article 15 is specifically about student. It's silent on parents. Again, we're still in discussions. If someone wants, anybody who has suggestions or things they want us to address, we have not submitted, nor have we even started meeting with administration, so we can still make changes to proposals. I'm going to put my email in the chat, and if you have something you want to make sure the team discusses, you can email that to me. Oops.
And I want to just say there's also a parent code of conduct. So that
Yep.
doesn't relate to the PS 74, but there are steps that principals can take to help protect you against that. So look up the steps that are taken when a parent assaults you or verbally assaults you, because they could be barred from the building. There's a whole list of things, and it's in I think it's called the Parent Code of Conduct or Family Code of Conduct. So, but that doesn't have anything to do with our contract, but that is something that PGCPS has developed and I guess are implementing.
And
if
Gary,
a parent assaults, threatens, harasses you, just as you can with the student, you can also go the legal route and go to the police as well. Again, you don't have to be subject. People don't get a free pass because they threaten a teacher. It's just like if you threaten anyone in the real world, you can't. There are laws against it.
And Gary, let me know if this is correct. When I'm reading Article 15A, principal's responsibility, it says the principal is charged with the responsibility for the total conduct in the total educational program to which assigned. So that loops that inappropriate behavior of the parent back to the administrator.
Yeah, principals in consultation with the area office can issue notices that parents are not allowed back in the school, do not trespass notices, et cetera. So principals have that authority. So if a teacher feels threatened by a parent's behavior, document it as best you can and request that the principal consider a action through the system to bar that parent from coming back to the school, or at least from contacting the parent directly. I mean, contacting the teacher directly.
And I would even add to that, the same proactive steps that we take for students, do the same with your parents. Like I have a parent that I already know, that if I met with that parent alone, anything could come out of there and be said that I did or whatever. So those kind of things you say, you tell the administrator, hey, I want you in that meeting. Or yeah, for the most part, you invite the administrator to meet with you and the parent when you have to interact. I would.
I would like to add, we always want to try to mitigate a situation, but we have to take threats serious. If someone threatens us, we have a right to take legal action. The climate that we live in today, if somebody makes a physical threat towards us and then say what they're going to do, that is a threat and it can be prosecuted under the law. It's not that we want to get anyone in trouble, but there's times that we know that administration kind of like does not move on, our initial request. And then who's to say something may happen after the fact? So we got to be real, take threats serious. It's not something that we should play around with. We just can't play around with threats. I don't think there's anything that an administrator can do to stop a parent or a student from attacking a teacher. They can't stop students from fighting in the classroom. So I would just say we got to take threats serious. If someone threatens me and I consider it to be a viable threat, I'm going to the police and then I'll let the school deal with it after that. That's just my personal position that I'm taking with the climate that we live in. We're not allowed to engage the students. We can't raise our voices at the students. We can't put our hands on the students. So now we're going to sit back and allow them to make threats towards us. We can't consider them to be idle or adjust. Here's a legal consequence of a threat that is not made in jest can be prosecuted under the law. I'm not taking any threat that another adult or student makes to me as jest or them just playing around. I'm going to take it serious. We can't willfully turn our head, and this will help us. I know I may be going on, but discipline is a big issue. Inappropriate behavior is a big issue. And the only way that I believe that we can support any type of positive change is that we start taking action, PF-74s, we take threats, take it to the next level, because administrators, in most cases, if we were to do the survey, are not taking action when teachers are being threatened, whether it's verbally and or physical in some cases.
And don't forget, that's why we have a union. That's why we have lawyers. If you go to the police, you're not going to be fired by the school system. We have rights. We have rights for our safety. Do not let anyone in your building intimidate you into keeping things under wraps and in building.
Okay, we have another question. I've written the PS-74. Do I have to follow up and place a hard copy in the principal's box, or do I follow up with an email?
I would say both, to make sure that they're adhering to what we are entitled to under the article. To do it just as an email, they'll say it was in my email. They could possibly say it was lost. At least with the hard copy, you have that hard piece to show as well.
Right, and don't forget, when you're doing the procedure for how do I provide the PS-74 to my administrator, it's an FAC communication. You come up to an agreement. So our agreement at our school is we provide 3 hard copies. I keep 1, 2 go into my administrator's box. And if I write it at 10 a.m. and I don't put it in that box till 2 p.m., I will write on both copies, put in administrator's box at 2 p.m. and the date, so there is no question when it was done.
Here's a good one.
Good one.
My school doesn't allow us to complete PS 74s. Rather, we complete behavior tracker forms and nothing is done in most cases. That's why nothing's done, because you're not completing the PS 74. That's the PS 74 is what is in our negotiated contract. That's what we pay our dues for. It is our right to complete the PS 74, especially for students where you have consistent behavior that is unchecked. Like, I will play nice with my administrators for nuisance behaviors, and do their other behavior tracker things if I just need the kid to calm down and sit in the guidance office for a little bit. I'll do that one. But if I have a student, which I have about 2, that are consistently unchecked and not doing what they're supposed to do, and the school is not doing, I write PS 74s all day, every day.
Just remember, the PS 74 you need to use if you doing your duties are being impeded by a student's behavior, anything egregious, you have a right to fill out a PS 74. And I've had experience with administrators saying, no, we don't write PS 74s. Yes, I do. I'm going to turn it into you. I don't know what you're going to do with it, but this behavior is going to be documented. So you can not do what you're supposed to do, but I'm going to do what I need to do. So you can absolutely turn it in. And then if they don't respond, then you go through that whole appeal process that we talked about. So you absolutely can submit it.
And
because
if I
I've had 2 principals say, no, we don't write PS 74s. The devil is a lie. Yes,
if I can piggyback on what Delisa is saying, and we work in the same building. In one of our instances, we were kind of with a principal who wouldn't really do anything about the PS 74s. Now we have a new administration, and this particular child, as other people were called in, wanted to see that documentation and data because he doesn't need to be at our school, right? He needs to be in a different school. But where was the PS 74s? Where was the documentation to support that? So it's made the process even longer now that we're trying to do it right. So again, the PS 74s is for our protection, is for the documentation. Again, this student should be placed in a different environment, and they wanted to have that data and documentation that we couldn't offer up because it wasn't done in the right way.
And just to piggyback on that, the students, so the behaviors have been, the behaviors have exacerbated. And so coming into this year, I've had to experience the student. And so it's ongoing. I've probably submitted, I don't know how many PS 74s. So we have a lot of documentation, but the behaviors keep continuing, even though they've suspended and so on and so forth. And so the last incident was the student hit me in the face with a book. And so just like we were talking about that slide, taking it outside and legal, going the legal route. So that's what I've done. So, whereas they tried to return, they suspended the student, but they want him to return to my class? Absolutely not. So I'm taking out an order of protection. So I've done the PS 74s, and I'm going to continue to do them. However, sometimes you have to go legal. And so that's what I'm doing.
So you are going to file the restraining order against the student? Do that
Yes.
ASAP, because if you don't, they can put him back in your classroom.
Right, right. Well, and I had, on the day that it happened, I did file a police report, and they said, they would let the school handle it if they don't handle it in the right way. I have my complaint, I have my report, and so that's giving me documentation for the order of protection.
May I ask a question? This is my fifth year in Prince George's County. From one of my other districts, our school police officers, we could file a complaint and report through. Can we do the same with the SROs in Prince George's County? Or do you actually have to go to the police department?
What I understand, everyone inside the building to some extent works for the county. And from my experience, the officers in the building try to keep it in the building without it getting out of the building. That's just been my experience. And some of them has actually asked the teachers, well, why you didn't come to me first? Because they have relationships with some of these kids also, because their job is to kind of help to keep them in and keep them out of trouble. So if you've been threatened physically or verbally, you have a right to go to the police office. Come on, let's look at what's happening within the school building. That's part of the challenge. We're allowing a lot of this stuff. We're becoming complicit in some form. I'm not saying that we want our young scholars to get in trouble, but if there are students reaping havoc in the buildings, especially towards the teachers, are we supposed to continue to take that? Our only recourse is to go legal in most cases, especially if they physically assaulted us. We can't feel bad about that, because we have families we have to go back home to, right? And I believe if we start taking those type of actions, the word will spread. And I assure you that students will take more serious how they communicate and talk to teachers. Because if the administration was doing a better job in preventing that, it wouldn't be happening at the rate that it's happening. So our protection, I believe, especially when it comes to physical assault, is to file a report with the police, because that's going to get their attention quicker than going to the administrator. In some cases, they talk the same way to the administrators. I've seen it firsthand. So again, I don't have any mercy for a student that does not respect what we do and who we are. I'm not against them. However, it's not all of them. It's probably only a handful. And if we take the proper actions, then the word will spread. And I guarantee you they'll consider the next teacher they try to assault or do something to. But if we never do anything, it's just going to continue. So at what point do we say, all right, enough is enough?
And on that note, as we wrap up, I want to just bring home a point, going back to what Wilbert was saying about being complicit. So as a union, Prince George's County Educators Association, we have a negotiated contract. In our negotiated contract, it says PS 74. We are being complicit by allowing these administrators to change our contract. It does not say a Google form. It does not say an in-house this or that or PBIS this. When there is an infraction and you're sending a student out of your classroom, according to our negotiated contract, it's a PS 74. And if we do what we have written in our contract more consistently, then we don't get to the point of where we have to feel like I got to go out to the police department to write a charge, because then people will begin to do their jobs. They will do what they're supposed to do. So please tell all the other members that are not on this call tonight, PS 74s. That's what we are supposed to be using. That's what is in our negotiated contract. That's what we pay our dues for. Let's unify, stick with the language that's in our contract, and make everyone comply to what's in our contract. Let's not be complicit and, try to be so rosy with everyone and do all of these different things. Let's do it based on what we negotiated for.
Thank you,
Second
Jay.
thing,
Yes.
in February 26th, our committee is going to meet again to go over the transfer process. Please pass the word. Let everyone know we're going to do a presentation on the steps for the transfer process. If there aren't any, let me see, I think I see another question. Okay, we have one other question. Same students doing the same things, and the principal will say no PS 74. I have told the parents no suspensions this year. The disrespect for students really increasing. Write that PS 74. Write your PS 74. It is in your contract. The principal can't do anything to you. And once you write the PS 74, then you have those steps that the principal must adhere to, and it is your right to hold the principal accountable or whatever administrator accountable.
And please don't forget, if you have an administrator like that that's refusing, that's what your union is for. That's what your UNISERV is for. That's what your FIC in the building is for. The principals get paid the big bucks to do the hard work. And if they're not protecting us, we have to protect ourselves, because if you're not writing those PS 74s and that child physically assaults you and you got to go to the hospital because you have a fractured something or other, then what's going to happen? You have got to protect yourself. Principal's not going to be there paying your bills. You have to pay your bills.
Okay, well, everyone, we thank you for joining us tonight. I hope that everybody got a copy of the link for the presentation. Go through it. Go through your contract. Know your contract. That's why we do these presentations, for you to know your contract. If your AR was not here, if your RA, your building rep was not here tonight, share this with your building reps so that they can go through this material that we created with the members in your building. Because the more we know, the less the administration can get over on us. And you know, our right is to write it with a PS 74 following the code of conduct instead of these other different forms. And did anyone else have anything they wanted to say before we end tonight? Okay, well, with that, we hope to see you again February 26th. Same bat time, same bat station. Happy New Year, everybody.
Happy New Year.
Happy New Year.